Right, 7:10, let's go. So civil procedure. Now, before I start, I suppose I should introduce myself. I've introduced myself to a few students here. Um, so I'll be doing civil procedure. I will be setting the exam for civil procedure. I will be doing civil advocacy, and I will be setting the exam for civil advocacy, okay? Now, there's going to be another tutor for civil procedure. I will be one of the tutors, and then another person called Vincent will be the other tutor. That tutor will do the tutorials on Zoom, and I will do them face to face. Okay. Now, my name is Alvin, and I was in private practice for about 5 years as a barrister, and I predominantly did civil procedure or civil litigation. After that, I joined the Department of Justice, and I'm there for about 3 years now, and I've been doing constitutional and administrative law, so judicial review. So that's my brief background, and we can just start now. If you're interested in knowing more about the practice as barristers and solicitors, you can always ask me after class. Okay, so I missed out on the textbook there, but I think everybody has access to this. Civil Procedure by, I think it's Dave Lau, but yours should be the 4th edition. This is 3rd edition. So this is probably the most concise textbook for students. And if you have any problems, it's really all in here. And most of the materials are gathered from this textbook, okay? So that's where the textbook is. Now we have the ordinances, High Court Ordinance, and then we have the rules of High Court. So civil procedure is really based on these two ordinances, rules of High Court Ordinance, and the District Court Ordinance. Now there's really no difference apart from jurisdiction from the rules of High Court and rules of District Court. There are some slight differences because some applications can only be heard in the High Court. But for all intents and purposes, we will refer to the rules of High Court, okay? I won't refer to the rules of District Court unless there are specific areas which I need to refer to, okay? Practice directions you don't really need to worry about. Those are way too practical. Now, where they are applicable, I will refer you to them, but practice directions are really addendums to the rules, okay? Case law, we'll go through, and they're in the textbook. So what's civil procedure? Question time, okay? Who wants to answer? It's a very simple answer, really. Civil procedure is really just the rules and the law which govern a civil litigation, and that's it. So if I want to sue somebody, there has to be some rules to govern the way in which I sue somebody and the way in which somebody defends being sued, right? And that's really what civil litigation or civil procedure is. It's all the rules starting from a writ action, governing how you serve the writ, how you sue somebody, all the time or timings involved in the services of processes, services of documents, when you have to file certain things, what applications you can take out, what applications you can't, so on and so forth. That is the gist of civil procedure. Now, I have a very brief, I tried to make a very brief, the general stages of a writ action, okay? Now, if you look at, for instance, the first table, you see the pre-action considerations. Now, these also form civil procedure. So, for instance, limitation period, which we will get into in a few slides, is really when can you start, or when is the time limit for you to start an action? So you guys have done tort, right? You guys have done contract. You guys have done all these different types of laws. So limitation is really, for instance, if I want to sue somebody for personal injuries, you have to sue them within 3 years of when the personal injuries occurred, right? Now, this is even before you start the action. You have to consider these matters. For contract, it's 2 years, unless you have fraud, so on and so forth. So these all go into what we call civil procedure. Conflict of interest, not really civil procedure, but it's pre-action considerations. Jurisdiction of court. Most of you will know that already. You have different courts, small claims, district court, lands tribunal, high court. Now, all of them have different jurisdictions. Usually, you'll only be worried about the amount. So I sue you for personal injuries or contract. The damages I'm claiming, $3 million. So you know $3 million is usually within the jurisdiction of the high court, right? Back then, before the legislation amended the jurisdiction, it used to be $1 million. So it used to be much lower. They amended it because too many cases were going to the high court, and the high court could not handle that caseload. So they actually amended it to a higher figure. So you have to consider also the amount you're claiming. Anything below $3 million, and I'm purely talking about the amount of damages, okay? You would go to district court, right? So we'll get into that. I'm just giving you guys a brief overview of all these things that are associated with civil procedure. Now, again, alternative means of settlement, mediation, those are part of civil procedure too. So some of you might know post-civil justice reform, the courts have been pushing mediation, arbitration. They don't want people to go to the court to litigate. They want people to settle the case outside of court. So that takes the caseload off of the courts. That also relates to procedure because it's within the rules that parties have to attempt mediation, okay? That's another example. So we go on, and through the tables, you see all the different types of processes or applications or matters, and those are all covered within the rules of high court, okay? Those are all civil procedure matters. Service on parties, statement of claim, defense and counterclaim, and you go down to discovery. And so that's why at the beginning I said civil procedure is really the whole of the rules related to litigation. And that's all it is, okay? Any questions on this brief introduction before we get into more detail? No? Hey. Okay. Now, so perhaps you can, this is, I suppose, quite an important slide because you can refer back to the general approaches at each stage of the writ action, okay? Now, before I get into that, I suppose, does anybody know what a writ action is? Okay, so a writ action is when you want to sue somebody, you have to, the writ is a document, okay? And you file that writ with the court and say, I want to sue you because you breached the contract. So every writ has to have a cause of action, okay? Cause of action, you will learn, for instance, tort would be negligence, okay? I sue you for negligence. And that would be the basis of the writ. So every litigation would begin with writ. There are other processes which we will get into, but a writ action is what starts the process, okay? The writ is what starts the whole civil procedure. And then every rule would follow from that, okay? Now, jurisdiction of the Small Claims Tribunal. Now, when a client comes to you and he says, I want to sue somebody, and you can see from the first point, exclusive jurisdiction over any monetary claim not exceeding, touch screen, 75,000 founded in contract, raise that contract or tort. Now, if somebody comes to you and they say, oh, this person A, has breached a contract, but the damages is only $50,000, you don't advise them to go to the high court or the district court because the amount of damages is below 75,000. So it's at the Small Claims Tribunal, okay? Now, for the small claims, you cannot have legal representation. So it's really the layperson who goes there. But for instance, if a friend comes to you, if a potential client comes to you, you would need to know how much the damage is, what they're claiming, and to correctly advise them of where the court they should go to is. Yeah. So second point is self-explanatory, and then section 5 gives you the authority for the Small Claims Tribunal. No questions here? Now, jurisdiction of the district court. Again, so if there's any claim about 75,000 to 3 million would fall within the jurisdiction of the district court. Now, this would be most claims in civil proceedings, unless the amount is exorbitant, okay? Unless you have a huge contractual claim, unless the relief is something that district court cannot grant. And you can see non-exclusive jurisdiction over any action for recovery of land where so what that means is non-exclusive means the high court can also entertain such a claim. Now, I've been talking about damages, right? Different courts also have different jurisdictions in terms of relief, okay? Some relief may not be associated with damages. Now, if you look at the ordinances, you can see certain provisions related to what jurisdiction the courts have. It would be specifically spelled out. Now, what can you envisage that the district court has jurisdiction over, apart from what I had just mentioned about the $75,000 to $3 million of contract, quasi-contract, or tort? Sorry? Yeah, so the district court does have jurisdiction over injunction and specific performance, and that's actually specifically spelled out in the ordinance, right? Now, what do you think the district court can also hear? Sometimes you hear that on the news too. Not necessarily criminal. It has criminal jurisdiction too, but this is more specific. You might not know this, but so if you guys have seen on the news sometimes, you would often hear about discrimination claims, sexual harassment, equal opportunities, right? I don't know if you guys have heard about that. So district court has jurisdiction to hear equal opportunities claims, okay? So if I bring a case of sexual harassment against my employer, my supervisor, this would be heard at the district court. And these are all within the rules of district court and the district court ordinance, okay? So you won't bring a claim of sexual harassment in the high court. You will bring it in the district court. So I'm talking about sexual discrimination ordinance, family status discrimination ordinance, disability discrimination ordinance, and the fourth one, which I can't remember, but there's 4 specific ordinances on discrimination. So those claims would also fall within the district court jurisdiction. Okay, so high court. So high court hears damages in terms of quantum above $3 million, okay? Everything above $3 million you would likely bring at the high court instead of the district court. Because if you do bring it in the district court does not have jurisdiction to award you a sum more than that. So you have to go to the district court. If you do bring it, you might have to apply to transfer the proceedings outside of the district court, okay? So Superior Court of Record, unlimited civil jurisdiction. So what does that mean? What does unlimited civil jurisdiction mean? So unlimited civil jurisdiction is just, as the student has just said, we have things, equitable relief, like specific performance, injunction. So the high court can make orders or grant relief that would otherwise be unavailable in the district court. For instance, if you look at the point, exclusive jurisdiction to hear judicial review and habeas corpus cases, okay? These proceedings cannot be started and cannot be heard and cannot be determined in lower courts. It has to be the high court because the high court has that jurisdiction to grant those reliefs and to hear those cases, okay? And of course, the Court of Appeal forms part of the high court, along with the company's court, bankruptcy court. Where's the family court? Yeah, that's correct. So family court is at the district court. I think I wrote that on the previous slide. I'm not too sure. Yes, yeah. So family proceedings you would follow and you would go to the district court. It's not that the high court cannot hear family matters, but usually the family matters that go to the high court would arise from trust type of proceedings, not necessarily ancillary relief. So I don't know how many of you have done family law. So family law, you have custodial matters, right? Parentage, kids, ancillary relief in terms of finances. So those would be at the district court, at the family court. But if something arises from trust, like family property, and they're arguing trust, then those would be, if the amount exceeds 3 million, would be at the high court. Yeah? Okay. Right. So I mentioned briefly about the transfer of proceedings, right? So if you bring a claim that is otherwise improper in the sense of the venue, if it should be in the high court, then you bring it at the district court or vice versa. There are applications you can make to transfer the proceedings. Okay. It's not your proceedings just don't end there, but you might have potential consequences. Okay. If you bring a claim wrongly in a wrong court, the other party might seek costs against you. So that's why in the first point, I says the district court can transfer or shall transfer an action to the court of first instance if the claim is outside its jurisdiction. And that is referring to either the damages sought or simply the matter cannot be heard at the district court. And it may strike out the action, okay, if the plaintiff knew or ought to have known that it should not have begun. So that's why I asked the legal representatives, when you receive a case, you need to know which courts have what jurisdiction to hear what cases, okay? Or else you might be liable to striking out and an adverse cause order. Usually in practice, they won't strike out the case. They will just transfer the case because it takes quite drastic or extreme circumstances for the court to strike out your case as a whole, as opposed to just transferring it. And usually practitioners would just pay the costs and then have the case transferred. But generally speaking, practitioners would not make the mistake of bringing a claim in the wrong court. All right. But the remedy is there for if you do end up making a mistake and bringing a claim where the court has no jurisdiction. Okay. So I think for the purpose of this class, you really just have to worry about the amount that's being claimed. And I think when I make the exam, I think for jurisdiction purposes, if I do ask you guys on jurisdiction, it will only be on the amount. I'm not going to ask you, oh, habeas corpus, where is it heard? I'll just simply say maybe the claim was for $4 million, then it's high court. It's as simple as that. But you ought to know everything, like when you practice. But for the purpose of this class, I think you only need to focus on the different damages, the amount that's being claimed. Yeah, simple enough. Okay, civil justice reform. It's about this. Without reading the slides. So civil justice reform, it says it was needed because everything was too expensive and too slow back then. So before 2009, litigation was quite adversarial. The system is still adversarial now, but pre-2009, practitioners were always trying to find ways to get more money from the clients. We still do, but the rules, the reforms have made it much difficult to do so, okay? So pre-CJR, everybody was trying to play with the rules to extend the litigation. So if you recall, back from the first, back here, each stage and each consideration takes time. If I take a long time with pre-action considerations, if I take a long time with pleadings, if I take a long time with discovery, if I take a long time with each and every step and start making all these applications at each stage, you would have a litigation that does not end within 10 years. And that was often the case pre-CJR, that cases were supposed to be heard within 1 year, 2 years, and finished within that time. But for the CJR, applicants, defendants would play with procedure to extend the duration. Whether or not that is as an abuse, so wealthy plaintiffs might play with the process and try to defeat the purpose. Defendants might or might not play with the process, but you get the point. So CJR was really to tackle that, was to tackle the lack of, as you can see, lack of equality. And with all the rules, which we see under the rules of High Court, Cap 4A, is to really make sure that every process is as succinct as possible, or that there is as minimal disruption to the flow of the process, which you saw with the graph. So we have what we know here, order 1A, which is the new thing under the CJR, which you ought to know because all practitioners almost always refer to this order when we deal with procedure, okay? Now, it's very broad. So if you read Rule 1, it says increasing cost effectiveness, so on and so forth. Ensure a case is dealt with expeditiously as reasonably practicable. And you see all these things about fairness, equity. So the reason why this rule was enacted or made was because this is what every single rule should be based on, okay? And every application should be based on. That's why this is called the underlying objectives. It underlies every single application. So if I, which we'll cover later, if I take out a striking out application, okay, I should also consider whether or not that will properly deal with the case quickly, fairly, and equitably, okay? So every application you have to consider, or the court considers these matters. Rule 2, it says, when giving effect to the underlying objectives, the court shall always recognize that the primary aim in exercising the powers of the court is to secure the just resolution of disputes in accordance with the substantive rights of the parties. Rule 3, parties and their legal representatives shall assist the court in furthering the underlying objectives. Okay? So instead of the parties and their legal representatives furthering their own interests, their duty is to further the underlying objectives. It's not that the legal representatives do not owe a duty to the client, but the overarching duty is to the court and to ensure that the matter is dealt with properly and that there's no satellite litigation, there's no abuse, there's no improper use of resources, whether it's the court's resources or the party's resources. All right, so these 3 rules you need to know. I'm not going to test you on them, but you need to know them, okay? I'm not going to ask you what these 3 rules are, but if you write them in the answers, then I suppose you get more marks. So here, again, it's a bit repetitive, but it shows you how much the courts are emphasizing the need for proper litigation, okay? Proper and effective litigation. So this shows you how the courts will deal with it in practice. So the courts will encourage the parties to cooperate with each other in conduct of the proceedings, identifying the issues at an early stage. And I'm not going to read all of them out, but I can tell you in practice, sometimes these don't really apply because it's hard for the court to encourage the parties to cooperate when you just started the litigation, right? So let's just say I started to sue you. I issued the writ, right? With the statement of claim. Well, the court can't encourage the parties to cooperate at that stage. But the point of this is to really press home to the parties, to the litigants, that you are expected to conduct litigation properly. That's the only thing. And fixing timetables or otherwise controlling the progress of the case, considering whether the likely benefits of taking a particular step justify the cost of taking it. So for instance, if you go back to the graph with the flow of litigation, you might think that I should take out a striking out application, or I should take out a Order 14 application, which is summary judgment, which we will get into. But is that, if you look at it, is the benefits of taking out that application, does that justify the costs of taking out the application? It may not, because the merits of the application may be very weak. But if you advise your client to take that application out, the courts might punish you and say, okay, under Order 1A, you did not really consider this, or you did not consider this properly. You should not have taken it out, and so you might have to suffer cost consequences, something along those lines. Okay? Making use of technology, the courts are still very high in terms of technology, but you get the gist. This is how the court approaches the civil justice reform. And in a way, they are quite serious about it, okay? Now, an example of this. how many of you have, I wouldn't say practiced, but how many of you have were paralegal or legal executive done things like that? No? So I suppose this example is not the best, but so there's something called time extensions, okay, in practice. Yeah. So see somebody nodding, but should have raised your hand when I asked. so, so there's something called time extensions. So for instance, I have a deadline under the civil procedure to file something within 14 days. Let's say that as an example. Now 14 days up, I haven't filed it. I need a time extension, okay? So me, I write to you. I say, can you agree to an extension of time of another 14 days? You're the plaintiff, I'm the defendant, okay? And I have to file something. So I write to you, and you say, pre-CJR, you say, F off. I'm not consenting with you. I'm not agreeing. Because the deadline is 14 days. You have to file it with 14 days. That was the attitude, right? Pre-CJR, you have to follow everything very strictly. Now, post-CJR, in this example, if you read it, I'll summarize it for you, is that the courts have actually, in their cases, issued a warning and said parties should, as far as possible, agree to time extensions if it doesn't prejudice you, okay? So if it doesn't prejudice you to give me an extension of 14 days, there's no point in arguing because you go to court and you argue, you're wasting the court's time because the courts will likely grant the extension anyway. So you're wasting the party's time for unreasonably refusing that time extension. Yeah, does that make sense? So post CJR, the courts are encouraging, this is an example of it, the courts are encouraging parties to discuss among themselves and to ensure that the case proceeds in a manner that does not waste costs and is as efficient as possible, right? So if you look at the last sentence, last 4 sentences up from this paragraph, it says, in which the registrar requires parties and their legal representatives to adopt a reasonable and practical approach to applications for extensions of time with respect to non-milestone dates, or else face cost sanctions. Now, non-milestone dates we'll talk about later, but very briefly, non-milestone dates are dates which do not affect the trial date, so to speak, okay? So there are 3 types of non-milestone dates. You have the trial date, which is at the end. You have case management conference dates, okay? I think those are the main 2, and interlocutory application hearing dates, okay? That should not be altered. So 3 main ones. In practice, I have an example of this actually. So when I was still in private practice, I had a case where the opponent, the defendant, had written to my solicitor seeking an extension of time for filing of certain affidavit evidence. Okay. Now I was okay with it, but my friend wanted to oppose the time extension. My friend did not want to consent. For whatever reason, he didn't want to consent. He was being adversarial. So he instructed me to go up to the master, High Court master, to oppose the time extension. Because if you don't consent to it, the person seeking the extension would have to make an application. And then the master will have to determine whether or not he should grant the time extension. So I went up, and then first thing the guy comes out was Master Deco. And he was telling me, he's like, Mr. Hall, he's like, why are you here? I'm like, I'm here on instructions to oppose the time summons. And he's like, why are you opposing? There's no prejudice to your client. There's nothing, you're just wasting my time, wasting costs. And he was speaking Cantonese and English. I don't know why he was doing that, but he was quite furious. And I said, I'm simply here on instructions. So even though as barrister, I'm acting on instructions of the solicitor. And he just kept going on and on and on. And obviously he was referring to this, that parties should agree to time extensions as much as possible, unless there are good reasons that you're opposing the time, okay? There's urgency, okay? In my case, there weren't that much urgency, but there could be situations where this does not apply. For instance, they have already sought 3 time extensions, and this is the 4th time seeking it. Then you might have a point in saying, well, why do they need so many extensions? I've consented to 3 time extensions already. I can't just keep consenting to a fourth, to a fifth. Then if I do that, then I can't prosecute my case, right? As a plaintiff, I can't just keep consenting. So there are situations where this does not necessarily apply, but the general approach nowadays is to consent. Okay? And if you don't consent and you waste the court's time, then we go back to the CJR stuff, which is expediency, efficiency. And that's why I say it's very important, Order 1A, because ultimately, all the practitioners would go up to the court and say the same stuff. They're wasting time. They're not being efficient. They're not being expedient. So everybody kind of goes back to Order 1A. So that's why it's the underlying objectives. Okay? All right. Okay, pre-action considerations. Conflict of interest. What's conflict of interest? I don't know. Don't look at me. What's conflict of interest? You actually learned this in PCLL, okay? I'm not going to test you on it, but basically, whenever a client comes to you, you have to check whether there's conflict in representing him. That's all there is. Maybe it's a relative. Maybe the other side has already given you the papers, right? So let's say I'm the solicitor. Party A comes to me. Hey, I've got a case. Can you represent me? And I say, okay, let me read the papers first. And I've read all the papers from Party A. And I said, okay, I don't want to do this case for whatever reason. I return the papers to Party A. Party B then comes over conveniently and says, oh, I've got this case. Can you represent me? But I've already read the papers for Party A. I can't then say, okay, I'll represent you because I already know everything for Party A. So that might be a potential conflict. There are a lot of different examples of conflict, but it's not what you have to concern yourself with here, apart from knowing that you have to consider it as pre-action. Authority to sue. What's authority to sue? I'm just going to keep asking you guys. What? Yeah. What's your name? Sorry. Alistair. Okay. What's authority to sue? Yes. The locus standi, that's the Latin for authority to sue, really, the standing. So who are you representing and who it is that you're suing? Are you suing somebody who cannot be sued? Okay. Is your client somebody who you can represent? So you represent a kid. You can represent a kid, but by next of kin, the parents, right? So the parents might be like, okay, this guy's underage. I'm going to act as his next of kin and sue on his behalf. So you need to make sure that person that you are representing, you can represent. How about a company? Obviously, you can represent a company, but what do you have to be wary of when a company comes to you? So you have to be, so a company obviously is a natural person. I mean, you guys did company law, but somebody represents the company, right? So you need the board resolution, right? So when a company comes to you, you're going to ask the guy, well, do you have a resolution? Do you have approval from the board that you can represent the company in instructing me? Because if you don't see that, you don't represent the guy. Because you don't know if the company has authorized this director to come to you to seek your representation of them. Okay? So that's really that's company. The Caesar's estate, can you represent him? Yes, provided that they have letters of administration. So when somebody dies, okay, they have an estate. So I die and then I've got my clothes and that's my property. That's my estate. Somebody has to handle that estate, right? And those are the executors or administrators. So when they come to you, you better make sure that they have the right to represent the deceased, not just because, oh, I'm his mom. Because just being his mom or parent or brother or sibling doesn't necessarily give them the right to represent the dead person. Yeah. So these are things that you have to make sure of when somebody comes to you. The limitation period, I briefly covered, we'll cover in detail. What's cause of action? Right. So instead of reason, I suppose it's the better term would be the basis for suing. The reason would be outlined after the basis, right? So for instance, basis is negligence, basis is tort, basis is assault. Basis is breach of contract, XYZ, whatever you want to. Basis is unfair prejudice. Okay. So that's cause of action. So as I've mentioned, with every writ action, you need a cause of action. There are very rare instances where you don't need a cause of action. You don't need to trouble yourself with that, but I can give you an example if you want, since we have a lot of time and I have to make use of the time. So if anybody remembers the Google injunction, anybody remember that? So that was, let's not use the Google injunction. Let's use the doxing injunction. You guys remember that? So remember back in 2019, a lot of police officers or random people were being doxed. And there was an injunction that was taken out by the Department of Justice to prohibit people from doxing people, from getting their private information and publishing it. Okay, that was an injunction. So an injunction is actually something that the high, well, in this case, high court granted, and you have to have a writ. And on that writ, you would need a cause of action. In that case, it was nuisance, actually. The cause of action was based on nuisance. So with every injunction, you need a cause of action. With every writ, you need a cause of action. Now, why I mentioned the Google one, you guys must know the Google one because that was on the news too. Google one was about the national anthem, right? Right. Well, not sorry, not the yeah. My apologies. It's not the national anthem. It's the other anthem. Okay. So that was the injunction seeking to prohibit the other anthem from appearing on Google search. Okay. That actually did not have a cause of action in the writ. That was actually a writ action, but it was based on what we call an action in aid of criminal proceedings. That's not a cause of action. And that is one instance, one example of when a writ has no cause of action, okay? You don't need to know this. I'm just sharing with you as an example. But for all intents and purposes, writ action, cause of action, okay? If you don't have a cause of action, you're going to be struck out. Order 18, which we will cover, because every writ has to have a cause of action or a reasonable cause of action. Okay, amount of claim and relief sought. We covered that, right? We know the jurisdiction, but you have to consider, let's say I'm claiming $500,000, but what are the legal costs associated with claiming that amount? Is it worth it? Or you're not claiming damages, you're simply claiming injunction. You're claiming for declaratory relief. So you have to assess all of these things or all these particulars before you bring an actual action. It's not just about, okay, I have a client, I'm going to sue him. He wants to sue somebody, I'm going to sue him. You have to assess whether or not it's worth bringing the action. Now, this is very, it's common sense, but we often forget when we're doing cases in practice. Jurisdiction of court, I've mentioned already, so I won't repeat that. Intended parties and their assets, okay? This is another important one, because if you sue somebody for $500,000 and you win, and of course, as a practitioner, you hope to win, does the defendant have that much money to satisfy the judgment debt? So if you win, does that guy actually, or is that guy capable of paying you $500,000? Because I can simply declare bankruptcy and I don't have to pay you anything, right? Or I don't have any assets in the amount of 500. Now, in that situation, so pre-action in that regard, you might have to ask your client whether or not they know anything about the defendant's financial background. In contractual cases, that would be easier because as businesses, you might know how they're operating, how much they're earning, but individual to individual, it might be more difficult. Yeah. 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 You mean dissipating the assets or? Mhm. Yeah. Yeah. Okay, so like a trust and stuff like that. So it's difficult because I mean, this question it requires a lengthy answer. So, if in his example, okay, we just take a break from this. In his example, if the wife sues the husband, and then the husband says, "Well, this property does not belong to me," technically, the wife would have known beforehand because the property would be registered in whoever's name, so they would know. So that's the first issue. The second issue would be the husband would still need to prove that the property does not belong to him, but to his parents on trust, right? Held on trust or not on trust. So he would need to show that either on paper at the land registry, the property is in the name of the parents, or somehow the parents have paid the full prices of the property. Okay. So it's not as easy as it seems, right? Does that answer the question? Yeah. Okay, so you have to know their assets, okay? Or if you don't, you're just going in blindly and you might get what we call an empty judgment, right? You might win, but ultimately you get nothing back. You can't get what you sought. Well, you won, but you can't get the money back, okay? Alternative means of settlement, okay? This, again, mediation, arbitration, don't need to worry about that. Costs associated with litigation, it's also part of, the pre-action considerations. How much is it? How long do you think the litigation will last? So if it's a big case, it's likely, if it's in the high court, you will need barristers, right? Right of audience. There could be a lot of interlocutory applications. So going back to the graph, there could be a lot of applications throughout. So you need to assess all of these, okay? And then enforcement of judgments. Is it easy to enforce or is it difficult to enforce? How are you going to enforce it? So if that person, and I know that person's bank account, and I know he has money in that bank account, it's quite easy to enforce unless he pulls out all the money, right? But assuming he doesn't, and I know his bank account, then I can simply do something called a garnishee order and then just sap the money away from the bank account. So you have to consider some of these, and you have to advise your client on some of these matters, whether or not it's worth it. So these are what is meant by pre-action considerations. Pre-action discovery is really whether or not there are documents that you need, okay? Because in a lot of litigations, you might not have the full set of documents and papers that you need to assess your case. So it might be necessary to do pre-action discovery. But for discovery, we will go into, I think, lecture 3, because discovery, after you started the litigation, it's automatic after pleadings, okay? So that's pre-action. Now, so I mentioned limitation there too, right? Okay, so limitation is self-explanatory. Limitation is just, let's say for contract, let's just say not under seal, let's just say contract, for 6 years from the date of accrual of the action. So you and I, again, we have a contract, and then you breach the contract. So you simply count 6 years from the date of the breach of the accrual of the cause of action and determine the deadline. So in other words, you have 6 years from the breach to commence the action. And that's as simple as that. So if you go through, there's different causes of action at different timelines. And I think the slide is rather self-explanatory. I don't need to go into specific detail. It's just the years, 2 years, 3 years, 6 years, or whatever cause of action it is. Now, what I should go into detail is the residual discretion. Now, for personal injury and death claims, the court has a residual discretion to extend the time limit. Yeah, and that makes sense because we're talking about personal injuries. Sometimes personal injuries, you might not know you suffered personal injury. For instance, asbestos, okay? We know asbestos from a long time ago. People were smoking or inhaling all the asbestos from factory work. Now, they didn't know that it was messing with their lungs, right? Until maybe 10 years, 20 years later. But the court's not going to say, okay, you should have counted 6 years or whatever years from the date of you inhaling the asbestos, because that would be unfair, right? Because they did not know that asbestos was causing harm to them. So the court has a residual discretion out of fairness, out of equity, to consider or to extend the period of limitation. So these are the considerations which the court would consider. Of course, the length and the reasons for the delay. If you can explain it, then the court is likely to allow you. But this residual discretion only applies to personal injury and death claims. It does not apply to, say, contract, and so on and so forth. Okay. Now, there are some. I think again, for the purpose of this class, you don't need to trouble yourself too much with this. But there are limitation periods which are not under the limitation ordinance. Okay. So different statutes may have different limitations for different causes of actions. Now, I've given two examples here. One example is sexual harassment, which is something that I raised as an example before. So if you go to the Sex Discrimination Ordinance, Cap 480, you will see the district court shall not consider a claim under Section 76, which is the sexual harassment claim, unless proceedings in respect of the claim are instituted before the end of the period of 24 months. Now, sexual harassment is not a tort per se, okay? Because it's codified under Cap 480. So it's not a common law cause of action. It's a statutory cause of action. And therefore, it is bound by the four corners of this statute. So you have to follow this statute as opposed to the tort one, which is 6 years, right? Make sense? So here, the example is you have 2 years to bring a sexual harassment claim. So this is an example of a statutory limitation other than in the limitation ordinance. Now, if you remember, when I just talked about residual discretion here, it only applies to personal injury and death, right? Section 30 of the limitation ordinance. But this section does not bar other ordinances from relying on these considerations. So what I mean is, if you read the third point, such limitation may also be subject to the residual discretion to override the limitation period. So because of the fact that Section 30 does not bar other causes of action, such as sexual harassment, from relying on the considerations to exercise the court's residual discretion, the court can, in sexual harassment cases, consider residual discretion and extend the 24 months period. Make sense? Yeah? Okay. So if you want, there's a case about residual discretion and the exercise of that discretion there. It's not, again, I'm not going to test you on this, but you need to know that you're not just looking at limitation ordinance. Even though the general limitations are set out in the limitation ordinance, you need to look at different ordinance too, depending on how you proceed with the litigation. Recovery of land, 60 years, 12 years. I really shouldn't write all these answers here, but who knows about adverse possession? Okay, so adverse possession is really when a squatter, I don't own the land. But did you guys do land law yet? Okay, so you know. What are you guys saying you don't know? But so adverse possession is really just a squatter living on the land adversely to the owner, and you have either 12 years or 60 years, depending on if it's private land or government land. Government land is 60 years, personal land or private land is 12 years. Now, this is a limitation, and this is actually reversed. It's a limitation for the recovery of land. So, I raised the question there. Why do you think an adverse possessor would not generally make a claim for adverse possession after 12 years? It's quite simple. So if I'm the squatter, I'm the adverse possessor, I'm living on your land, free of charge, free of rent, and I built my own crap there. Why do you think I would not actively seek a declaration that the right to recovery has extinguished? Well, not you, I'm pointing at you, but anybody. It's common sense. Because if I'm there illegally, I don't want to start proceedings and alert you that I'm there firstly, right? So usually, when I put the question why, usually, purely for your information, adverse possessors would wait until a claim is made against them. So if I'm the true owner of the land, I come and I realize there's an adverse possessor, I would seek to kick you out. But obviously, I can't do it forcefully, right? I have to go through the legal process. And if I do that, then that is when the defendant would assert that the limitation period for you to recover land within 12 years has expired. So I'm not going to actively be like, I'm an adverse possessor. I'm going to wait until you do something that you know about my existence. Then I raise it as a defense, quote unquote, and say, your limitation to recover land has expired, be it 12 years or 60 years. Okay? Is it a writ action? Let's say it's the defendant making the claim for whatever reason. Is it by writ? Remember that a writ has to have a cause of action. What's the cause of action here? If the defendant, adverse possessor, is seeking to extinguish the recovery of land, the right to recovery of land, would it be a writ action? Would the defendant issue a writ to the plaintiff and say, okay, your right to recovery has been extinguished? Alistair? Okay, what is it? That's correct, it's no, but what do you think it would be? Okay. So I talked about writ actions, right? Writ actions have to have a cause of action. What's the other originating process? No. Yeah. Okay, we got several ones. Yeah. So OS, okay, originating summons is the other originating process. Now, OS, you do not require a cause of action. It could be on a point of law. And the recovery of land is a point of law, whether or not the right has been extinguished, right? Whether or not it's 12 years. So if a defendant wants to, without the plaintiff issuing case against him, if the defendant wants to claim adverse possession and make a declaration that the right to recovery of land has extinguished, the defendant would issue an OS, originating summons, to the true owner, okay? How about a plaintiff then? If the plaintiff wants to recover land against the adverse possessor as the defendant, what is it? Is it a writ or is it an OS? Yeah, so it'll be a writ. If it's the plaintiff claiming against the defendant for recovery of the land, return of the land, then it would be a writ because the cause of action would be possession of the land, vacant possession, return of vacant possession of the land. Yeah, makes sense? All right. Okay, legal aid. I'm not an expert on legal aid, even though I deal with a lot of legal aid. All you need to know, okay, is that there are two schemes. And apart from that, you also need to consider for your client whether or not they are eligible for legal aid, right? Because if they can't pay, they're not going to pay you. And so they need legal aid. And you're going to be getting paid from legal aid, okay? So legal aid, there's the ordinary scheme. And that is available for any person whose financial resources do not exceed $420 and then $400. Not too many people are eligible for legal aid because if you count a lot of people's financial resources, it might most likely be above 420. Yeah. Everything. So basically what happens is when that person applies for legal aid or when you assess whether or not your client is eligible for legal aid, you'll have to basically look at all their finances and they're provided to you, assuming they don't lie, okay? Then if they do lie, it's not your fault, but they will provide everything to you, you know. Usually it'll be property or the lack of property, and then bank accounts are really the major assessors or considerations you would make in terms of how much they actually own, right? And then you can read those yourselves, what it covers, okay? Certain things it's covered, certain things it's not. Yeah? I'm not going to test you on this, in case you're wondering. And then there's the supplemental scheme, which is available to those whose financial resources exceed the previous amount, but does not exceed 2 million. Again, you'll have to assess finances. You have to ask your client. Usually, when they come to you, they'll tell you outright that they need legal aid, but they don't need legal aid, okay? Because they are in a better position to know their finances than you do. And if they lie, they lie. Because ultimately, it's their legal aid that's being rejected, right? Okay, and you can read that yourself. I'm not going to test you on this. Apart from the means test, which is what I just mentioned about the amount of resources the person has, his finances, there is also the merits test, okay? So you can't just say, okay, I have no money, grant me legal aid. You also have to pass the merits test. And the merits test is essentially whether or not your case is strong enough to warrant defending or bringing the claim, right? And considerations which are made by the legal aid department are those in the bullet form, right? So you might have to go through them with your client to consider whether they are not clear. But you see, the thing is, you can make the application anyway and push the work to LAD, legal aid department, and they will do the assessment themselves. Yeah. But obviously, you don't, if it's completely unmeritorious, you don't want to tell your client to apply for legal aid. Yeah. Basically, I've kind of explained it, and the case is there. If you want to read more about it, Dave Lau's textbook has a whole section on legal aid. But it's not something that I can assure you that I'm not going to ask anything on the principles of legal aid in the exam. Okay. And that's another slide. That's another slide. Now recap on pre-action considerations before we take a break. Okay, we'll just recap. What's the most important thing before you issue a writ? Just throw it out. No wrong answers. When you issue a writ, what do you need when you issue? Huh? Yes, yes. Cause of action. You need a cause of action, okay? So you need to know what has happened to your client, right? You need to specifically ask him. Because there could be examples, and I'll give you an example of a case. So about 5-6 years ago, there was a case about harassment, not sexual harassment, okay? Harassment, general harassment. So what happened in that case was two neighbors living in the same building. Neighbor A kept on, quote unquote, harassing neighbor B, swearing at him at the elevator, pushing him, touching him, so on and so forth. Now, obviously, if you touch the guy, it's common assault and crime, but he didn't want just criminal sanctions against neighbor A. He wanted to sue him in civil proceedings. Now, general harassment under tort back then was not a recognized cause of action in Hong Kong. There was no common law harassment, okay? So neighbor B started a writ action against neighbor A on the basis of harassment. Now, harassment is recognized in UK law, okay, back then. So when it went to court, neighbor A sought to strike out neighbor B's claim because harassment is not a cause of action. It's not recognized, okay? And obviously, when it went to court, the court heard the parties' submissions, and then the court recognized and said, okay, now we recognize, starting from now, that the tort of harassment exists in Hong Kong. So my point is, sometimes you might think that there is no cause of action because it's not, quote unquote, recognized yet in Hong Kong. But it may be the case that if there are other jurisprudence in other jurisdictions, you could rely on it and argue the case before the court might, okay, might recognize it. But if you have no cause of action, you will be liable to be struck out and your case simply fails because there's no basis for you to sue the guy. Yeah? That's what's most important about writ. You guys want to take a break or you want me to keep asking questions? I'll still ask after the break. Oh, he wants a break. Okay, let's take a break. 10, 15, 20 minutes, and then we'll continue with, we have a bit of slides. So we'll just continue. Yeah, let's take a 10, 15 minutes break, okay? Or however long you want. By the way, if I'm not clear with anything, you can just ask me, okay? Because I might not, because I might be just telling you guys from my experience. So I might be very, like, very straightforward with it. But if there's anything that requires clarification, just tell me, and I'll. 喂，有啦係嘛？即係下邊應該有噶啦。啊，我就嚟開噶啦，未開。Let's start 8:25. Okay. Okay. Before I start, actually, assuming I get a say in this regard, what do you guys want? Open book exam or closed book exam? Okay. Wait. Open book. Raise your hand. Open book exam. Raise your hand. Okay. There's one. Okay. Well, I can't. I can't. Well, that's what you get for not coming to class. So, so there's one guy who wants open book exam, and then what about the rest? Closed? Okay. I'm sorry, mate. I'm sorry. Okay. Now we're getting people typing. Since the majority here wants closed, I'm leaning towards closed. Um, but I will have to confirm with the administration whether or not they want me to do open or closed, because ultimately I might not get to decide. I decide on the questions, but yeah, okay, it's very good advocacy, but most people are saying closed, and you didn't raise your hand when I asked who wants open. So, uh, okay, I'll let you guys know the results. Everybody wants closed, okay? You can check the chat afterwards if you want, but okay, let's start. Let's say it's leaning towards closed, okay? Okay. Okay, commencement of proceedings, okay? I covered all of this already when I started talking early in the lecture, right? So let's go back a bit. So the forms of originating process. The first and biggest one is the writ of summons with the cause of action. And then you have originating summons, which is what I talked about, law. You have questions of law with buried dispute in fact, okay? So adverse possession or when you're seeking declaratory relief. Now, yeah, then you have originating motion and then petitions. So those, the latter ones, you don't have to worry about. Those usually relate to appeals or specific applications under specific statutes. And that's why in the next point, I said choice of originating process. Sometimes it's not really for you to decide. It's based on the claim that you want to make. So if you are suing somebody with a cause of action, it's writ action. Okay. If you want to, again, determine a point of law, OS. Now, here it says, unless a statute or court rule states otherwise, civil proceedings may be started by writ of summons or an originating summons. Now, notice how it doesn't say originating motion. So with originating motion, you only use originating motion when the specific statute says to use an originating motion. That's it, okay? Therefore, you only need to know for this class, writ and OS. Now, as I've said, the writ of summons, OS, are not the only ways in which you start civil proceedings, okay? So we talked about sexual harassment, and I always use this example because it's a good example because I can use many different things to explain to you how there could be differing procedures. So if you look at sexual harassment claims or discrimination claims, such as sexual discrimination ordinance, it's not a statement of claim. It's not a writ. It's not an OS. Under the rules, Cap 336G of the District Court Equal Opportunities Rules, you issue what is called a notice of claim, okay? And then you follow those procedures under Ordinance 336G. So the point is, it's not a writ action. It's not an OS. It's specific category. Obviously, the consequence might be the same. You're suing somebody, but the procedures are different, okay? So, again, when you are starting a claim, you need to make sure what claim it is you're starting and follow the relevant procedure. That's just one example. For your exams, for your tests, it'll probably be a writ. Most likely it won't be an OS, okay? So it'll probably be a writ. Now, another example is what we call forfeiture proceedings. Now, like I give a lot of these examples for your understanding, not that you need to know them because it doesn't really assist you in in this course or even in PCLL, but it helps you understand. So forfeiture proceedings are when you have criminal cases. So let's say I commit a crime of smuggling. I'm smuggling cigarettes, right? I get caught and the customs, they seize the cigarettes, right? And once they seize it, because it was used in connection with the offense of smuggling, importing or exporting unmanifested cargo, and that's the offense, I would get charged, and the cigarettes are the subject matter of the offense. They would seize it. And what happens is the customs would issue what is called a notice of seizure. I've seized these cigarettes. They are for this offense. If anybody claims these cigarettes as being the truthful owner of these cigarettes, for instance, I'm just carrying it, I'm smuggling it, doesn't mean it belongs to me, right? I'm just the criminal. The cigarettes might belong to some other person. That's the true owner. The true owner can actually make a claim for these cigarettes. And so what happens is, under this ordinance, to start a claim, the claimant, the true owner of the cigarettes, has to file a notice of claim under or pursuant to this ordinance. So not all actions are writ actions or OSs. There are very niche, okay, specific matters which can also begin a civil procedure. Get my drift? Example again, it's very niche. You don't need to know it. You probably will never touch upon this in practice, but it's there. Now, originating summons, I have, and this is somewhat important in the sense that the OS procedure is different from a writ, okay? So a writ, I can briefly summarize, issue the writ, statement of claim, we'll go through this later, statement of claim, filing of defense by the defendant, finish with the pleadings, those are called pleadings. You have discovery of documents, which is when the parties exchange documents, everything that's relevant to the proceedings, witness statements, any expert evidence, and then setting the case down for trial, and then appeal, if any. Okay, that's really the writ action. That's all there is to it. OS is a bit different. If I start the claim or civil procedure with an OS, it follows that specific process that's stated there, or briefly summarized there. With every OS, you need an affirmation or affidavit in support, okay? Whereas with a writ, you don't need that. A writ, you write the pleadings. With a writ, you use the statement of claim and defense. With OS, you use affidavit evidence in support of the OS. Affidavit evidence is just sworn evidence, yeah? And you follow that procedure. So in a sense, it's quite expedited because you can see once I issue the OS, if it's with an affirmation, then the defendant has 28 days to file a reply affirmation. So it expedites the whole process. And the reason, why do you think OS is so much simpler than writ? Because for writ, I talked about all the processes, you know, discovery, yada, yada, yada. But why is OS so simple and so quick? Because of the nature of it. What's the nature of OS? Yeah, so OS is really very little dispute of fact, right? Mostly just question of law and the application of the facts. So with an OS, you file the affidavit. If there's a dispute in the facts, the defendant would file the reply affidavit. And that's it. You have the battle of the two affidavits, the two evidence, and then you go to court, and then the court makes a ruling. That's really what the OS is. Whereas with the writ, you actually have much more to deal with because of the pleadings, defense, statement of claim, and then witness statements, and all the other interlocutory matters, which I mentioned in that very first slide with the graphs, right? So that's OS procedure. I won't test you on OS, okay? Writ. Now, the duration of writ, when I issue a writ, when I sue somebody, I take out a writ. And that writ is actually filed to the court, okay? You have to file the writ to the court before it is served on a party. Now, that writ, once you file to the court, you can choose not to serve on the defendant. You simply file it with the court. Now, once it's filed, you have 12 months or 1 year to serve the writ on the defendant. What's the point of doing that? Why would you file the writ and then not serve it on the defendant? Maybe it could be the case that clients change their minds. It could be the case that you haven't actually finalized all your assessments of the pre-action consideration, right? Because you could be in a rush. Say the client comes to you, and I've kind of written the answer there, and the limitation period is about to expire. So say 3 years is about to expire, you have no choice. You need to issue the writ because once you issue the writ, or you file the writ, you are considered to be within the limitation period, even though you don't serve the writ until 12 months later. So you might file the writ and then within that 12 months, consider those pre-action considerations, okay? So here, that's why they call it protective writs. You simply file the writ, but do nothing until the deadline comes. And you can do all your assessments and so on and so forth. It doesn't really happen that much in real life, from my experience, because usually people would bring their claims within limitation and they don't need to use protective writs, but it's there, okay? And the rule is there. You have 12 months to serve the writ. And once the limitation ends, you can extend it further for 12 months. Okay, so writ, statement of, so we've talked about statement of claims, writs, and writ and what that. What's this? What's the statement of claim? So the paralegal up front. Right. So a statement of claim is what we call a pleading, right? So a pleading is the formal term of so there's three types of pleadings, okay? Statement of claim goes with the writ. Defense and counterclaim, if any, is an answer to the statement of claim. And the third one is a reply and defense to counterclaim, if any. Yeah? So these are all pleadings. And a statement of claim goes with the writ because you are setting out what you are claiming against the defendant. And it is in the statement of claim that you have your cause of action. Yeah? You say who the plaintiffs, you learn this in PCLL. You have to outline who the plaintiff is, who the defendant is, or defendants or plaintiffs, and you have to outline the statement of claim and all the particulars in support of that cause of action. That's what the statement of claim is. Essentially, or in legal terms, the statement of claim is the plaintiff setting out its case against the defendant in a manner that the defendant understands the case against him. Okay? It has to be that. Failing which, if the defendant does not understand your claim, because you can draft the statement of claim very poorly, you can have a bad cause of action, you can have very bad particulars. If the defendant does not understand the claim, they can make, again, what we call interlocutory applications, civil procedure stuff against you, further and better particulars, interrogatories, striking out, so on and so forth, okay? So the statement of claim has to be written in a manner which is understandable to the defendant and fully discloses the plaintiff's case. Now, you learn this again in PCLL. Statement of claim, there's a difference between pleading, writing facts, and writing evidence. What's the difference? Facts versus evidence. Yeah. Yeah, that's correct. But so can you think of an example? You're correct, but can you think of an example? What would be a fact? Let's say you want to sue me for what? Negligence. I accidentally hit you with my car. Yeah, yeah. Wait. It, yeah, yeah, yeah. Okay, yeah, yeah. Well, so okay, so what you said would be better labeled as particulars. Okay. Evidence. So, for instance, the car example, the fact is I hit you on 6th of January 2025. That's the fact. Okay. The evidence would be CCTV footage, witness statement. That's the evidence. Now, in the statement of claim, when you write a statement of claim, you do not write evidence, okay? You do not plead evidence, you plead facts. He hit me on the 6th of January, 2025, in a white car, driving at 60 kilometers per hour. Now, I have evidence to prove all this stuff, assuming I do, that's why I'm bringing the claim. But you don't need to write the evidence in. You don't need to then say, I have CCTV footage, and that's recorded in a CD. That's evidence. And that will be disclosed in witness statements or during discovery, okay? The fact is simply what happened, which gives rise to the cause of action, okay? So that's briefly statement of claim. You'll learn about that in PCLL, how to actually draft it with facts, not evidence, okay? General endorsement of claim as opposed to statement of claim. What's the difference? Well, okay, the answer is there already. So, a concise statement of the nature of the claim made or the relief or remedy required in the action. So why would somebody? So this is an example. This slide is an example of a general endorsement of claim. Okay, that's the document itself. This is something that I did before. Why is it so short? Because usually statement of claims would be much longer. This is a very concise statement of what is being claimed and why I'm claiming it. That's it. This is called a general endorsement. Does anybody know why I would use a general endorsement? Yeah. But why not just do the statement of claim outright and serve it with the writ? Because with the writ, you either have to serve it with the statement of claim or general endorsement. You can't just serve a writ. It's either serve the writ with the general endorsement or serve the writ with a statement of claim. So why would I choose a general endorsement over a fully fledged statement of claim? Okay. Why? Why would I simply want to do that? Why would I want a simplified version of what I'm claiming as opposed to everything? Because after I file the general endorsement, right, I still have to file a full statement of claim. It's not that I filed the general endorsement and I don't have to file the statement of claim. I still need to file the full statement of claim after the general endorsement. So why would I file the writ with the general endorsement and then wait and then file the statement of claim? I mean, it's quite, one, the reason could be I don't have enough time. I'm just going to write the general endorsement. I mean, it's a silly answer, but one is simply I don't have enough time. Second is really just urgency. So sometimes when we seek injunctive relief, I want to prohibit you from doing something, and it's very urgent. I can't possibly write out a full statement of claim with all the particulars, with all the quote unquote facts before I want to stop you. Because you might be doing something tomorrow, and I need the injunction now, today, and I need to file that writ now. So I will do the general endorsement with the writ and then take out the application. Because with the general endorsement, you can write this within 10 minutes. Whereas a statement of claim, you really need to verify all the facts that you're writing before you write it in the statement of claim. Make sense? Yeah? The general endorsement is simple and concise, okay? And I have it here, I just didn't turn to the slides. So usually made because of urgency, such as applying for an injunction, where it may be impractical to furnish a statement of claim, okay? And the last paragraph is really on the full statement of claim, not the general endorsement. And I think I should impart on you the importance of, oh, sorry, I missed out some, yeah. So this guy, Wang Chuck Lun, said time constraints, so he's right. But so statement of claim, um, it's very important that you write your statement of claim properly. Okay. And the reason behind that is your statement of claim, your defense, or what we call pleadings, okay, is the foundation of your respective case, as the plaintiff's case, as the defendant's case. If you have matters which you have pleaded improperly or contrary to the rules, the other side will take issue, okay? For instance, if I did not plead a certain defense, which is required under law, and by law it means procedure, you might not be able to raise that at the trial, and it might be too late, okay? Now, at the early stages of the civil litigation or the procedure, you might be able to amend it, and we'll talk about amendments later. But you have to ensure with all pleadings, everything has to be proper, okay? Everything has to be pleaded in accordance with the rules. We covered this, right? Who to sue, briefly covered it. Natural person. Now, if that person is under a disability, and disability, it must be a recognized disability, such as a mentally incapacitated person, he can make a claim by his next friend, okay? But must act by a solicitor. So, for instance, if I'm not disabled, you can still act for me. You don't need a solicitor. But if he's disabled, his next friend who's suing on his behalf must be represented by a solicitor, okay? And this is just simple. Sole proprietor, you can sue because he owns the business. He's a sole proprietor operating a business. Partnerships, okay, it's written there. Partnerships are two persons operating a business. When you sue them, you have to sue them in the name of the firm of which they were partners at the time the cause of action accrued, right? So if accrued 5 years later before, then at that time when they were partners and the name of that firm. Body corporate, of course, you can sue, or if you're suing somebody as a body corporate, you have to instruct solicitors to represent you. And that goes back to when I said the director would need a board resolution, approval from the company to instruct solicitors, okay? So that is rather straightforward. On the point of parties, okay? We know about joined, what's joined of parties? It's basically, okay, you see the order there. I mean, you don't, when in the exam, you ought to write the order if you remember the order, okay? So this goes back to whether or not you want an open book or closed book. Because with open book, you can kind of refer to the orders, okay, if you forget. With closed book, but then with closed book, I might not really be too harsh if you can't recite the order, but if you can recite the principle. So this is Order 15, Rule 4. So what happens with joinder is two or more persons may be joined together in one action as plaintiffs or defendants with the leave of the court, and it goes on. So why do you need joinder of parties? What's the point of joinder of parties? I think the answer is in the next slide, but why do you need joinder of parties? Why do you need to join somebody else to your case? So I sue you, but then you want to join him, or I want to join him or her. Why? No. So why I want to join them is really just to avoid what we call duplicity or multiplicity of actions. So, for instance, in the car crash scenario, let's say I'm driving the car and then one of you is sitting next to me. And then I was negligent and I was driving and I crashed into somebody, or somebody crashed into me. And I get injured, you get injured, and that other car gets injured. The driver of that car gets injured. You can sue me, right? Because I was negligent in driving the car. And I can sue somebody else because he was negligent in driving the car. So you have several parties who might be negligent. Now, he sues me for being negligent in driving my car and causing him personal injuries. I can then say, well, it's not my fault. I then sue the other driver for being negligent too. Now you have two actions, right? He's suing me, I'm suing him. But in essence, the whole thing is one case. It's one event. So the court may, or the parties may, if the parties don't, the court may consider consolidating the action and then joining all the parties together to hear the same case at once. Because if you have two cases, then you have double the amount of potential civil procedure applications, right? You have one timeline that's going on here, he's suing me. You have another timeline that's going on here, I'm suing him. So to avoid duplicity of actions, the court may consider joining the parties or joining the action, okay? Depending on whether or not the cause of action is similar, depending on whether or not the parties are relevant to that cause of action. Make sense? I think that's quite clear with that example of the car crash. And obviously, I've listed it there. Also, the relief claimed in the car crash case, the relief claim obviously is damages arising from the car crash, the personal injuries. So it would make sense to join them, right? So joinder of parties in practice, I would say it's not uncommon in the sense that usually you would have decided, or most solicitors would know which parties to sue in the first place. And it would arise in situations where perhaps new evidence comes to light after they've begun the writ, after they've begun suing that party. They realize, oh, this guy should be sued too, or this other party should be joined too, right? And that is just the Order 15 Rule 1 as to how you consider joinder of causes of action, right? So instead of parties being involved, is the cause of action. Yeah, what's up? Ladd and Marshall. Yeah. No. So Ladd and, oh, you're testing my law. So Ladd and Marshall is the adducing of evidence on appeal. Yeah. So Ladd and well, you don't have to concern yourself with that here. So Ladd and Marshall, if I just touch upon that briefly, is on appeal, whether or not a party is allowed to adduce additional evidence that was not adduced at first instance. That's Ladd and Marshall. And there are three conditions. I can't remember the conditions now, but that's Ladd and Marshall. So it's not relevant to answer your question to this. Yeah? Okay. Service. Okay, this is actually a big part of the lecture on service of the originating process. This you have to know, okay? Better stand up. Okay, so let's say you start an action by writ or OS. Two ways to do it, right? Writ or OS, both of which are called originating processes. And they're called originating process because they start the process. They originate the process, okay? They begin the civil litigation. They begin the civil procedure. Now, under Order 10, you have what we call personal service. And as the name suggests, you leave the copy of the writ or of the OS with the person to be served. Now, it's a rule that when you leave it with him, if you want to effectuate personal service, you have to tell them what it is. You can't just freaking throw it at them and be like, here, you have to tell them this is a writ of summons. Here it is. It's in this envelope, okay? And if the recipient goes like, okay, I don't want it. I don't want this. You still have to leave it to them. And after you do the personal service, you have to file an affirmation, sworn evidence that you filed it on this day, in what manner, where, what time, to who, okay? That's personal service. Now, once you do that, if it's done correctly, the service is deemed to be effective, okay? And service just means delivering the document to that person, okay? In law, service means actually starting that process, because if it's not served, it's not started. If I don't know the process against me, it's not technically started. So you can argue, or the defendant can argue, that it's ineffective or irregular service, okay? Now, in most situations, nobody does personal service nowadays, okay? Because you can't find the guy. Unless you can find him, then that's good, because it's easy to just leave it with him. But in most situations, you can't find the guy. If I want to serve it to her, then the only time I can see her is probably like now, tomorrow, during lectures. But otherwise, if I'm not in lectures, I can't find her, so I can't serve it on her personally. So in most cases, in most situations, in most litigations, we would rely on Order 10, Rule 1-2, which is the alternative to personal service. Okay? And that either means by sending him a copy of the writ by registered post to the defendant at his usual or last known address. What's usual and last known? That depends on what your client tells you. Okay? Or it could be the registered address under the land, his property where he lives. But even then, you might not know. So it's all inferences, okay? What the client tells you, what his correspondence address is, and that's what you use as his usual or last known address. The second option to personal service is that you insert the writ or originating process into the letterbox. Letterbox is the mailbox, okay? They just call it an old name. Now, I raised the question here, how do you find a person's address? It's a practical question. How do you find his address? If I want to sue somebody, I want to sue you, you want to sue me, how do you find my address? Yeah, yeah. Well, a company would be easy, right? Because usually company would advertise their address, or you can find it at the company's registry. But you want to sue me, personal. So remember, natural person, you can sue a natural person. How do you find my address? What might be some ways to find? Okay, I keep missing their comments. I'm so sorry. I missed a lot of comments. So can we have the PowerPoint slide files instead of PDF? Okay. Land search, last known post address. Yeah, so you can do a lot of searches, whether or not it's through private investigators, whether or not it's from your client himself, he could tell you stuff, or correspondences, okay? What you should do after service, I already told you, affirmation of service. You have to say that you've served the thing and when it is. Please brief facts. Yes, that's enough. Actually, that's a good point. So in certain cases, people might report the crime or event to the police, and the police might take statements from the relevant parties. And in those statements, you would get potentially the address of that defendant or plaintiff, and so on and so forth. Now, service. Now, why is service so important? As I've mentioned, is that it begins the process, okay? You need to serve on the defendant, the originating process, so that the process starts. Now, Order 10, Rule 1-3 helps the plaintiff with that. Because in situations where you can't find the plaintiff, when you can't find the defendant, and you might know his address or you might not know his address, and you insert the thing into the letterbox, you don't know if he's read the thing, right? You don't know if he's opened the letterbox. You don't know all of that. So under Order 10, Rule 1-3, 3A, it says the date of service shall, unless the contrary is shown, deemed to be the seventh day after the date on which the copy was sent to, or the case may be inserted through the letterbox for the address in question. Now you need to know this, okay? 3A, you need to know the deeming provision of service. Because there are situations where people would argue that they never received the writ or they never received the originating process. And it's easy for a defendant to say that, right? I never received it. I don't know about it. They could be away from jurisdiction. They could be in jurisdiction, but they simply never checked the letterbox, right? So this deals with what we call default judgment, which we will get into later. Default judgment is basically when people do not file a response to the statement of claim or writ. Okay, we'll get into this later. You don't have to worry too much about it. But right now we're on the deeming provision of service. So this case, Barclays Bank of Swaziland and Han talks about service and what happens when a defendant is outside of jurisdiction and has no knowledge of the said service, okay? Essentially what happens in most of these cases, you can read the facts, but I'll summarize what happens in most cases in practice is I go to Thailand or something. Somebody puts the writ into my letterbox, but I'm not within jurisdiction. Okay? I'm outside of jurisdiction, and I also do not know about the writ that has been inserted into the letterbox. because I don't have anybody at home to open the letterbox for me, to check the contents for me. Because sometimes I might have a helper. Sometimes I might have my mom, I might have my brother or whoever who checks the letterboxes and opens it and then texts me, oh, you got a court document. It's a writ of summons. Then I would have knowledge, even though I'm out of jurisdiction. But in some cases, the defendant would say, I'm not in jurisdiction and I have no knowledge of it. Now, in this case, he has knowledge of it, albeit he was out of jurisdiction. The court in this case, the thing you have to know, really worry about is there are two requirements, okay? And the two must coincide. First, before service is deemed to be effective on the defendant has to be in jurisdiction. And jurisdiction means Hong Kong. We're talking about the civil litigation in Hong Kong. And two, he has to have knowledge of the existence of that originating process. And in this case, being the writ. Okay? Those are two things you need to know. Now, since the time I did my law degree, it's been debated whether or not this is actually a good principle. Because you can envisage intentionally silly situations or absurd situations where I'm not in jurisdiction, I'm in Thailand, the writ is inserted into the letterbox, my brother finds the writ, tells me about the writ, so I have knowledge of it. But I can then say, because I'm not in jurisdiction, I can then say it's not effective service because the two conditions do not coincide. So you have absurd situations like this. Okay, I don't really agree with it. I think knowledge is sufficient because presumably if I'm in Thailand and I have knowledge of the writ, I can get somebody to file what we call the acknowledgement of service, which is really to acknowledge that I'm going to defend the case. I see the writ, I'm going to defend the case, okay? So, but if you look at the law, if you look at the jurisprudence of this requirement, there have been differing authorities, okay? Some authorities have said that only knowledge is required. Some authorities say that both are required, okay? But for our class, both requirements are required, okay? The coincidence of defendant within jurisdiction and that he has knowledge of the writ, okay? And as a matter of fact, that is where the law actually stands, even though it might be somewhat wonky. And this is the case you want to cite, okay? Now, I've talked about briefly about the consequences of ineffective service, and this slide effectively deals with that. So with every writ and every statement of claim, when I serve it on you or on the defendant has to file what I just said, an acknowledgement of service, right? Which is to acknowledge that the writ has been served and I will now defend the proceedings. Obviously, the defendant can say, I don't want to defend the proceedings, but usually the defendant will say that I will defend the proceedings and I contest it. So if the defendant does not file that acknowledgement of service, the plaintiff can apply for what we call a default judgment, okay? Under Order 13, Rules of High Court. Default judgment simply means default of acknowledgement of service, okay? There could be defaults of other stuff, but in this situation, if I give you the writ and you don't file, the defendant does not file the acknowledgement of service, I can make an application for default judgment and say, well, defendant, you did not file the AOS, acknowledgement of service, within 14 days, therefore you're in default, and I can get a judgment against you without going through all of the other procedures. Basically, you win the case. The plaintiff wins the case if the defendant does not file an acknowledgement of service. Okay, that's the starting position. Now, I've set out the requirements for fulfilling that default judgment very briefly, and that is that the writ has been duly served. And if you remember, you have to file the affirmation in support, how the writ has been served, when it was served, so on and so forth. That the time of acknowledgement has expired with no such acknowledgement, which is the 14 days period. And then it goes on, it goes on, it goes on. Now, to start this, we'll discuss this later in the subsequent lectures when we talk about Order 13. But since it is immediately relevant to service, I have put this here. Okay. But we will go into that in detail. Yeah. Any issues? No? Okay. So service unlimited companies. So she just mentioned previously, companies is much easier to deal with than persons, natural persons. Okay. Companies, you can simply rely on section 827 of company's ordinance, the new one, and you can simply serve it on the company's last registered, not last registered, but the registered office of the company. Or you can actually serve it on the address that they put forward as their usual operation address. Okay. So that's quite straightforward because usually companies would advertise their address, or you could easily search up their registered address at the company's registry. And if you leave it there, then it's pretty much deemed to be served on that company. So company is much easier. It's not that they don't dispute service, but for purposes of service, compared to serving on natural persons, it's much easier to serve and to effectuate service on companies if they're in Hong Kong. Okay, if they're in Hong Kong. So if you look at the 10, it says Rule 1 is not intended to apply to service unlimited companies in view of Order 10, Rule 17, but instead it is governed by Section 827 of the company's ordinance. So Order 10, Rule 1 was what we had just covered on personal service, alternative service. Instead, when it's limited companies in Hong Kong, use Section 827. Okay? Partnerships, you have to serve on them individually, okay? Because partnerships are different from the nature of partnerships are different from companies. So you have to serve on each partner individually, okay? And they are, in fact, usually when you sue them, they would be sued as different defendants, not as a partnership as a whole. And I've listed that more. You need to know them. I won't test you on service on partnerships. Okay, some other matters on service. It's okay. So all these rules can actually be dispensed with in the sense that if the parties have actually agreed on how to serve documents. So, for instance, in contractual disputes, sometimes a contract will include addresses for service, okay, and how documents should be served on each party. Now, this is a private dealing between individuals, but that overrides the rules. So, if company A and company B has agreed on the address for service, then you simply serve on the address and on the mode that is agreed, because those companies can agree to service by email. And if it's agreed between the parties, then you can simply serve on them by email at that email address, and it would be good service. And then this slide lists out all the different other matters on service. So for possession of premises, if you look at the last point, service must also be made by affixing copies of the originating process on conspicuous parts of the land. Okay? Now, this again is very niche and only deals with land processes. But what that effectively means is if I want to go and serve a process for the recovery or possession of premises, that notice has to be fixed on conspicuous areas. So, one, perhaps the lobby of the building, and then obviously another one in front of the flat itself if I'm seeking recovery of that specific flat. Yeah? Okay, I don't know why the slide is here, but can you serve process on Sunday? Yeah. Well, yes, no. Emergency, yeah. So I can serve. Well, the general rule is you cannot unless with the permission of the court. Okay. And to be honest, I really don't know why this slide is here, but you can't unless you seek the court's permission to serve on a Sunday. And obviously, you have to make an application, and it has to be supported by affidavit evidence as to why such a service is needed on a Sunday. Service out of jurisdiction. Okay. We talked about service within jurisdiction, right? So everything I talked about before was serving on defendants within the jurisdiction. Okay. People, companies, partners living in Hong Kong. Now, what if that person you're trying to sue is not in Hong Kong? How do you start the proceeding against him? How do you start the civil procedure against a person outside of Hong Kong? Well, you have a writ. Let's say I have a writ, I have a cause of action, I have all those ready. And now I want to sue this guy who's living in Malaysia. How do you do it? You have to serve the writ out of jurisdiction. You have to bring that writ to the attention of that person in Malaysia. Okay? Now, Order 6, Rule 7 says you can't serve a writ outside of jurisdiction unless with leave of the court. Okay? So you will always, when you seek to serve out of jurisdiction, make an application by summons because you started the writ and then you take out the summons and you apply to court to serve the writ outside of jurisdiction. Okay? Now, all these are what we call gateways to serve outside of jurisdiction. It has to be under one of these before you can serve out of jurisdiction. So either the relief sought is against a person domiciled or ordinarily resident within the jurisdiction, an injunction is sought, a claim is already brought, so on and so forth. Usually what you will see is the gateway of contract being used, okay? Because that would be most common. Why is that the most common? Because usually you would be contracting with a party that's out of jurisdiction. You're buying stuff from China. You're a manufacturer. You're a supplier. You're now dealing with international bodies, okay? That is the usual gateway. Usually you won't have a claim in tort that you need to serve out of jurisdiction unless the guy hurt you and then he flew away and he moved to another country, right? Because presumably if that guy is out of jurisdiction already, he's not going to be able to commit a tort against you unless, say, it's harassment. through the internet or something like that, right? So usually you would see contractual disputes that require service out of jurisdiction. Okay. Obviously, there are cases with other gateways, but from my experience, it's usually the contract ones. Okay. So the fourth point, a claim to enforce, rescind, dissolve, annul, or otherwise alter a contract. The fifth one, a claim for a breach of contract committed in Hong Kong. Okay. So these are the gateways that you have to rely on. Any other gateway, you cannot serve out. Okay. It must be these. Now, apart from showing that your claim rests under one of the gateways, you have to demonstrate, again, the first point is to demonstrate that you have a good arguable case upon the gateway which is relied. What's a good arguable case? It's not merely just telling the court that there's a cause of action, that I have a contract. It's not that. It's good, quote unquote, good arguable case means that you have some merit to that case, okay? So if you guys, maybe you guys have learned this. So there's this term called serious issue to be tried. Maybe you have, maybe you haven't. So this term, serious issue to be tried, merely means that you can show the court that there is a cause of action and it's kind of believable. You don't really have to show merits. Good arguable case means you have to condescend into the merits of the case, okay? You have to at least show the court that your case is good, as opposed to merely that I have a case. That's the difference, okay? And then the second point you have to show is the plaintiff should depose mean by affirmation, to his belief that he has good cause of action against the defendant. So if, in a sense, you pass the first test, you sort of can pass the second test, yeah? And then the plaintiff should depose to where the defendant ought to be found or is likely to be found. Because to serve out, the court has to be satisfied where you're serving the thing, or serving the originating process, is the place where the defendant is. And all of this requires extensive research, okay, as to where the defendant might likely be. And you will have to ask your client, you'll have to do background checks. And then there's also the requirement to demonstrate that Hong Kong is the suitable forum. Because what exactly happens is when you serve the writ out of jurisdiction, you're still trying to sue the defendant in Hong Kong. You're not trying to sue him elsewhere. You're just trying to serve the writ to him there and ask him to come to Hong Kong and begin the civil procedure in Hong Kong. So that is why another requirement is that Hong Kong is a suitable forum for hearing that case. And those factors listed outside or listed under are what the court will look at. Location of witnesses. So for a contract, you may or may not have witnesses, but for other case, you might have a lot of witnesses. So you need to assess where the witnesses are. If the witnesses are all in Malaysia, then the court might think, well, I'm not too sure if we should try this case in Hong Kong, right? Because I'm not going to call 10 witnesses from Malaysia to come to Hong Kong. It's not very appropriate. Applicable law, and that really deals with contracts. So if you guys have seen contracts, usually you have governing law within the contract. Which law governs this contract? If it's stated that governing law is somewhere else than Hong Kong, then that usually is the end of the matter, because the court will likely say, well, if the governing law is not Hong Kong, why are we trying the case in Hong Kong, right? Because there's no point, because the Hong Kong courts don't know Malaysian law. Let's say the contract says the governing law should be Malaysian law. There's no point in trying the case in Hong Kong if Malaysian law is applicable to the contract. Just try the case in Malaysia, because then the courts will have the expertise. Then the lawyers there will have the expertise to try the case. Places of business, location of the subject matter, language to be used. Those are all considerations as to where the matter should be tried and whether or not the writ should be served out, right? And then the last consideration, or the penultimate consideration, is will holding the trial in the other form prejudice the plaintiff or deprive him of any juridical advantage he may have in Hong Kong. So these are all very practical considerations. So let's say it's in, what's a very dangerous country? I mean, it's quite disrespectful to say it's Yeah, so okay, so anywhere in South America, he said it, not me. So let's just say it's South America, okay? Um, or anywhere that the plaintiff might be at risk of danger, then the court would also consider that. But obviously, that has to be shown through very succinct evidence, okay? Very established evidence that the plaintiff may suffer or may be at risk of danger. And all of these require affidavit evidence. And the court is not likely to grant a service out unless it is completely convinced that the appropriate forum is Hong Kong, okay? And then obviously balance any detriment suffered by the plaintiff with the juridical advantage. So another thing is really just Hong Kong has a quite robust judicial system, right? As you all know, the system is based on common law, and the court really would, in a way, consider the judicial system in the other area where the defendant resides. For instance, if it does not have a proper judicial system, then it's really clear that the weight will shift towards allowing the matter to be heard in Hong Kong. Because otherwise, if you hear the matter in, I don't know, let's just say a random country in Africa, I don't know which one, but let's just say they don't have a proper judicial system, then the detriment to the plaintiff or the prejudice to the plaintiff would be so great that he would not gain or have any juridical advantage if the matter was heard in Africa as opposed to Hong Kong, right? So service out is that. It's very brief, okay? It's actually it's much more complex than what I have given you. But I can't really cover that much within the 5 lectures. For what you need to know, it's there. I think I've actually covered more for service out than previous lecturer. Um, you're not going to be tested on service out. So, but you need to know it. And then there's substituted service, okay? And substituted service is when I want to serve a writ on you in Hong Kong, okay? But I cannot serve it on you, okay? And as the first point says, if it appears that it is impractical, if it is impracticable for any reason to serve the document in the manner described, the court may make an order for substituted service of the document, right? And when does this occur? So sometimes this occurs when I try to effectuate personal service, but I can never find the person. Okay, so I've had cases where there's a frivolous plaintiff, and I've been trying to serve documents on her, and I can never find her for whatever reason. She just moves around. She doesn't have a fixed abode. Okay, she no fixed address. She no registered address. I don't know where she is. I can only guess where she is. And I've done that once, I've done that twice, I've done that thrice, and she never answers, okay? In those situations, then I would have to make an application to the court and say, okay, I've tried my best to effectuate service in the normal means, okay? In the ordinary means we had just discussed. But nobody ever answers, she never shows up. The court may then hear the application and say, okay, I'm satisfied now. I'm satisfied that all the efforts in effectuating ordinary service, by ordinary, I mean what we had just discussed, cannot be used to effectuate service on this person. Therefore, I will allow substituted service. And what substituted service is the name suggests, is I will allow you to use a different method to effectuate service. The most common is to publish the document, whether it's a writ, whether it's the OS, on the newspaper. If it's in bankruptcy proceedings, it would be the bankruptcy notice of the hearing. So it's not limited to newspaper, but it's the most common one, is the most commonly used. It could be by WhatsApp, okay? I've seen that done. But you really need to show the court why WhatsApp would be the only reasonable manner in which that person can receive the document, okay? Or email or in other manners, okay? Or the court may even dispense with service, okay? And by dispensing, yeah. Yeah, 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 yeah. it factors in. I mean, like the courts are more and more ready to allow service by those mediums. Okay, but I suppose I have to qualify that by saying that for originating processes, the court may still be reluctant to allow that because, as I have said, originating processes are what starts the whole civil litigation process, and that is very important. And you can't just at the outset be like, okay, I want substituted service because I can't find the defendant. You have to follow the rules. And the courts are quite adamant with that in regards to originating processes, okay? It's only after many tries that you can't and you fail that you apply for substituted service, okay? And that's in practice. You never apply it at the outset unless your case is extremely strong. Yeah? And even then, I have some reservation as to whether the court would grant an order for substituted service if you've never tried the original service methods. Yeah. Right. So this is the practical stuff, how you make the application. It's for your information. You never have to write this in the exam, okay? I'm not going to ask you how to do an ex parte application and stuff, but it's for your information. You'll learn this in PCLL, okay? So just focus on the principles, really. And then here's the time. Here's the time. I would actually advise you for this to read the textbook on time. Because sometimes I myself get confused with all this stuff. So it's under time periods in the textbook. I have the old version, so I don't have the page numbers for you. But it's under time periods, and he actually gives you examples of how to calculate the time. So for instance, let's do one example, okay? So let's do number 2, okay? Where the act is required to be done within a specified period after or from a specified date, the period begins immediately after that date. This sounds like a bunch of gibberish because like what do you so if you read the examples, the example it gives is, for instance, if a writ is generally endorsed, okay, we get into the timing of this afterwards in lecture 2, but if a writ is generally endorsed, which if you remember, general endorsement versus a full statement of claim, if a general endorsed writ was served on the defendant, the plaintiff, right, has to then file a statement of claim, if you remember correctly. He can't just file a general endorsement. If he files a general endorsement, he has to file a statement of claim 14 days after filing the general endorsement, okay? So if a plaintiff files a general endorsement and then he files the statement of claim within 14 days, the defendant has to file an acknowledgement of service, right? Remember, he has to acknowledge service. So acknowledgement of service is 14 days from the statement of claim. Therefore, according to his example, if the acknowledgement of service was filed on the 17th of January, this is why I tell you to read the textbook, because I'm probably doing a bad job of explaining this. The deadline, actually, I think I messed it all up. Just read the textbook on this. Yeah. No, it's much clearer than me, okay? The textbook is much clearer than me on this. So, but the rule is this, okay? That's how you calculate all the time. And the textbook has all the examples. Okay, and that's the end of this lecture. But I think before we end, we can have a Q&A. Because it's easier for us to answer questions and to talk about what was discussed. Okay, first of all, is there anything that I talked about that you want clarification on? Because I might not have been the clearest in the manner in which I delivered the points. Anything. Don't say it's good, because I don't think it's that good. So, nothing? Really? Well, you can always ask me afterwards, or you can ask me tomorrow, or you can ask me Thursday, Friday, review sessions. But this is the first lecture. It's supposed to be a bit more general in terms of all the scope. We're not at the substantive applications yet. So when we get into the substantive applications, we'll talk about really how to do the applications and really the law involved. Yeah? No questions? There's questions you get. Let me just check. Sorry, there might be some questions here. I keep forgetting. Is this course case law heavy? Mm, civil procedure is case law heavy. Okay. Um, I wouldn't expect you to cite cases for every single point that you make. But for instance, remember the case I talked about, Barclays on the service? Then you need to know that. Okay. Some cases, which I refer to in the slides, you might want to cite. I'm not going to expect you to have other cases which is not talked about inside. Okay. But if you happen to cite those cases, then all good for you. I'll probably give you extra marks. Okay. So civil procedure is case law heavy because a lot of the procedure is in the rules of high court. Okay. Cap 4A, but it only outlines the rule. It doesn't actually tell you how it's applied in most situations. But that's where case law comes in. Now, if you guys know, let me just go back to the front, the beginning. So textbooks, actually, there's a book called the White Book, okay? So for those who practice, you know the White Book is, so it's the White Book. It's called Civil Procedure in Hong Kong, okay? And every year it comes out with a new edition. And we call it the Bible of Civil Procedure because with every order and every rule, there is commentary on how that rule is applied and all the cases that go with it. You don't need it, okay? You're not going to go through the White Book and then write it on the exam because it's not going to happen. But to answer that question, it is very case law heavy, but you're not going to need to write all these cases for me because even I don't know all the cases that are applicable to each and every single rule, okay? That was her question, or his, Gareth, that was his question. Okay, let me just go through. If you want to leave, you can just leave. I'm going to go through their questions. So one person asked, please advise how to calculate the last day of loan recovery under the limitation ordinance. 6 years after the principal due, the last repayment, if beyond the loan expiry or any movement of the loan, e.g. interest accrued. You don't need to know that for this course, okay? Just good question, but you don't need to know it. And then the example you just gave about parties agreeing on emailing, is that an example to Order 10, Rule 3 on slide 41? So maybe we'll just go there. Like I said, you guys can leave if you want. I'm not stopping you. I'll see you guys tomorrow, yeah? Whether by Zoom or in person. Where is he? Right. So that to that question, under Order 10, Rule 3, if it's agreed by contract, okay, then you can serve it in the manner that it was agreed. That's it. Can we get the PowerPoint version of the slides? Yeah, I will tell Bessie to give them to you or to upload them. Yeah, have a good night, okay?